Hello, I'm Michael Feltman, immigration attorney located in Dodge City, Kansas. This is episode 11, Benefits in the Immigration Court. If you're following along, first question is benefits. One way to obtain those is through the immigration court. There's a number of different types of benefits that you can seek if a person is in removal proceedings. Some are court-related specific by law. Some are benefits that you can obtain through not only the immigration court but also through other routes as well, through what we call USCIS. First common one that we generally look for right away as an immigration attorney is something that's called cancellation of removal. With cancellation of removal, there's 4 different variations of cancellation of removal through the immigration court. Cancellation of removal is only through the immigration court. If you're a permanent resident in removal proceedings, there's a cancellation route. If you're somebody that's just considered to be here illegally, there's a cancellation route as well. There's also what we call a VAWA cancellation route, and then there's some specific countries that have their special provisions for cancellation of removal. Each one has their own specific requirements. A second common route to seek for relief in the immigration court is something that's called adjustment of status. Perhaps it's a new application for adjustment of status, or perhaps it's just you have your permanent residency but you're wanting to reapply because it's being taken away. That's one route. A third route is called asylum. Asylum also has some related provisions as well, something called withholding of removal and convention against torture. All 3 of them really revolve around being afraid to return to your home country. Each one has some specific requirements. There's some time requirements that you need to watch out for as well. If you're applying for asylum through the immigration court, it's called defensive asylum. A 4th common category we'll see pop up in the immigration court is something called temporary protected status. We call it TPS for short. There are specific countries that's been designated by the United States that are too dangerous for different reasons to return back to that home country. It doesn't provide permanent residency as far as what's considered a green card, but it does provide some protected time to remain in the United States until the United States says otherwise. With TPS, a lot of the time you can obtain a work permit. A 5th common route is something called what we call a victim visa. There's different variations of that. Most common one that we use in our office is called the U visa. It's not something that's actually sought with the immigration court. It's with a different department within the Department of Homeland Security, but it is a great benefit in trying to fight your relief for removal. Perhaps one of my favorites in relief for removal is something called administrative closure through what they call prosecutorial discretion. What is that? It's basically letting the court case fall asleep. It's not terminated. It's just basically closing the books on it and putting it back in the file and say some other time until that time comes. I've seen cases that have been closed for over a decade. There's positive factors, there's negative factors to consider, and in making this request, which actually goes to Immigration and Customs Enforcement, not the immigration judge, you want to present those factors, the positives, the negatives. You want to provide the whole picture so that they can have a good evaluation of whether or not this qualifies under their criteria for using what we call PD or prosecutorial discretion. Another form of relief that's not obtained necessarily through the immigration court, through the immigration judge, but something that we've been able to see that helps a lot of young folks is something called deferred action for childhood arrivals. We've discussed this before, just the general overview requirements. If you may fall into those requirements, it's a great benefit to try to seek while you're in final proceedings. Last form of relief, if no other options are available, is something called voluntary departure. What does that mean, voluntary departure? What that is leaving the United States on your own, at your own time, without being forced to leave. You're promising the court that you will leave when the judge says it's time to. The max amount of time is 120 days if it's before a final trial. If it's after what we call post-conclusionary voluntary departure, the max is 60 days. There's some other requirements that go along with that. Voluntary departure is better than a deportation because a deportation carries with it some other penalties, such as a 10-year ban from being able to return back. But there's some waivers we'll talk about in the future too. Thanks for listening. I'm Michael Feltman.